First, welcome to my live show on Facebook. Today, I'll give a very important update about Zambrano case law as a carer of British citizen, irrespective of whether British citizen is child or an adult. This is the further development of EU settlement scheme. As you know, under the EU settlement scheme, there are a couple of changes which following the Zambrano case. We encourage people before to make the application before 30 June 2021 because there are a big difference, a lot of difference, significant difference. Those who made application before 30 June 2021, but those who fail to meet the deadline, they still can make the application. On what basis? I'll tell you today. The main theme or main policy is Zambrano application deadline, which is basically extended 6 weeks more by the decision of the court. So if anyone missed the deadline, still you have an opportunity to make the application. Now, there are a lot of questions, what is Zambrano, right? So basically, by way of background, this case was initially a European Court of Justice case from 2011. Under the Zambrano carer, only carer get a limited leave to remain or pre-settled status under EU settlement scheme, but they cannot switch to settled status. However, the Arkansas case, which give a right to apply for settled status, although the Home Office appeal to the Court of Appeal, so the outcome of the whole application will depend on the outcome of the appeal. However, we are encouraging who are care of a British child or British citizen should make an application even after 30 June 2021. Now, this was by way of a consent order with by the Home Office, where the court agreed, where the Home Office agreed, Home Secretary agreed with the court that they will accept application after 30 June 2021. And so this is important if you are a carer of a British child, if you are providing carer of an adult British citizen, and if you don't have a leave to remain, or if you do have a leave to remain but on 10 years route, you can make an application under EU settlement scheme. There are a lot of advantage to get a status under EU settlement scheme. For example, there is no fee just if you already spend 5 years under EU settlement under Appendix FM or EX1 as a carer of a British child. You will get directly indefinitely to remain rather than wait for further 5 years and paying NHS fee, Home Office fee, ILR fee, £2,400, life in the UK test, and all other requirement, English language. You don't need anything. You don't need life in the UK test to get ILR under EU settlement scheme. You don't need a life in the UK or a B1 English language test to get settled under EU settlement scheme. So this is a unique and great opportunity. Now, in my previous video, I advise client, my viewers and the client that to make the application 30 June. But now I'm encouraging again those who miss that deadline 30 June, you can make application up to next 6 weeks. So those who are providing care, or if you have got leave to remain on the basis of your relationship with a British child, but of course you have to be a carer because you need to understand that if you get, you must be a carer, primary carer, to get exercise Zambrano right of residence. So if you get a leave to remain on the basis of just a court order, child arrangement order, you might not be able to get settled status because you are not the primary carer. Because the main principle of the Zambrano, what the Court of Justice said, that if EU child required to leave to outside the EU because her parents or carer is going outside the UK, outside the Europe, then the carer will have a right of residence. So if you are just a parent who are not providing carer, who are not the primary carer, if you left the UK or EU, the other parents could provide the care. So child doesn't need to move outside the EU. So you'll not get on that perspective. So you have to be a primary carer. Now, big question. I have limited leave to remain under EX1 for 10-year route. Should I make an application? If I made an application, what will happen my leave to remain? Will my leave to remain cancel if I make, because I can't make a two parallel application? This is the question for many people. And for professional, I myself had this question. This answer, the answer of this question given by the judgment itself. If you have an opportunity, look into the order. In a recital 3, it said, if you have leave to remain on other part of the immigration rules, such as Appendix FM or human rights basis or EX1, this application under EU settlement scheme as a carer, as Zambrano carer, will not affect the other right to limited leave to remain or enter, or if you make any subsequent application, that will not affect, or the decision or outcome of Zambrano under EU settlement scheme decision will not impact or affect your other application. So the answer is no problem. You can make an application is under EU settlement scheme, which will not revoke or cancel your other leave to remain. Now, this is not a guarantee that you will get settled or pre-settled status, because I said it will depend outcome of the appeal. Home Office has already applied to the Court of Appeal for permission to appeal. Now, if the Home Office win, then all the application will be rejected. However, it will not impact, it will not affect anything, because it will not cost you. There is no fee for this application. And so you should take that chance, you should take that advantage. Don't miss it, my viewers, because this is a great opportunity. And most probably, Home Office will lose, because the way High Court explained it, the law, that the Home Office misunderstood the EU rights, EU law, and in terms of Zambrano carer rights under EU settlement scheme, and the case, what the explanation given by the High Court Justice most times. So it is. I don't think that the court will overturn the decision. So if you are a carer, please make the application, but don't worry, it will not affect your other leave to remain. But the advantage, as I said, you will get, there is no fee. You will get, some people will get directly indefinite leave to remain, because those who already spent 5 years on the basis of the relationship with a child, they will get indefinite leave to remain directly. They don't need to wait for further 5 years. Those people who already spent 2 years, they will get pre-settled status, but once they spend another further 3 years, they will complete 5 years, and they can make another application in 2023 or 2024 under EU settlement scheme for settled status. Again, there will be no fee, no other requirement. Another advantage, those who just need to apply for under UX1 on the basis of their child is a British citizen, or someone they're providing care as a carer, they will get 5 years pre-settled status, and after the 5 years, they will apply for directly indefinite leave to remain, or ILR. I hope I cover all this question, but still, if you have any question, feel free to make a comment on live Facebook, where from you are watching, whether from any YouTube or Facebook live. You can leave a comment. I'll try my best to give you an answer, especially on Zambrano right. Now, this case is very important, because this is the case which extend the deadline for EU settlement scheme. EU settlement scheme, the borderline was 30 June 2021. Only this is the exception. There are other two exceptions: general exception, which is reasonable grounds, and exceptional circumstance, someone can make application after the 30 June. This is applicable for everyone. Okay, but this particularly Zambrano right of residence, where Home Office agreed with the code that yes, we will accept application for the carer of a British child or carer of a EU child after 30 June until we consider the immigration rules under Appendix EU. And what is the reasonable time? Probably 6 weeks. So you have up to 6 weeks to make the application. what will happen if you make the application? Whether your leave to remain will continue. Yes, if you have whatever status you have, will continue. Now, those who already make the application before 30 June, there is better position without any doubt. But those who will make the application now, again, if you are lucky enough, many people make the application, but majority people doesn't know, and they fail to make the application 30 June. So for those people who missed, now make the application. I have received a couple of questions, but I'll come back. Let me explain you a bit more about what document you need to provide with the application. Now, to make the application, you need to be very careful first, because you cannot make application just you are a parent, just because you are a parent. You have to be a primary carer. If you are not a primary carer, or you can be jointly a carer as well. So you can be a sole carer or a joint carer, jointly, okay? And the situation has to be like that. If you require to leave UK, there is no alternative person who can provide care for your child. That means the child has to live with you to go to back home. In that case, Home Office will give you pre-settled settled status because of the child, because it's derivative rights. It derived from the EU citizen, EU child. That EU child have a right to reside, and their carer has the right to reside. So you have to be a carer of the child. It's not just because you are a parent and you will get, because you have to be different. That the right to remain on the basis of human rights, Article 8, and the Zambrano carer. And the document, again, you have to provide supporting document evidence on your claim that you are primary carer. Now, how you are primary carer? You provide day-to-day care for your child. Okay, normally the mother, most of the case. I don't know how many fathers change their napkins of their child, but some good father, yes, good dad. There are a lot of people who provide a primary care or jointly with their wives. Of course, they can claim as well. Who took the GP? Now you provide day-to-day care to your child. You cannot prove. You cannot prove by evidence. Yeah, right. Okay, you cannot prove. But what you can prove, who from the GP letter, who is the person in primary contact? Because if you take a letter in the GP, there is a phone number for the child in their record, and a guardian or parent or mom or dad name, who is the person in primary contact. So you need to obtain a letter from the GP that you are the person who is person in primary contact for the child well-being. So that GP record will tell you that you were the primary carer, number one. Second, this is the very important to document. I'll tell you. Second document is very important. This is the first one. The second one is a letter from school. Who took the school, the children, who meet with their class teacher, who meet with their tutor, who attend the parental meeting, who bring them, take them, communication, whose phone number in the school record. School will give you a letter. Tutor will give you a letter. Social care will give you a letter. That will define that you are the primary carer. You have to give these two documents. If you just claim I'm the primary carer, it will not work. Zambrano right of reside is very sensitive. Many people's application will refused by the Home Office just because they fail to establish the primary care. Because you know what? I'll tell you, people are making application, okay, because they are thinking open gate EU settlement scheme, the way EU citizens are getting pre-settled status and settled status, just make an application and everyone getting pre-settled status. Zambrano right will not work like this. Zambrano application will refuse massively because you are not the primary carer. So you have to establish these documents. You have to satisfy the Home Office that you are the primary carer. What else you can give? What the evidence you get? Now, this application you have to made by online. Okay, sorry, excuse me, is paper-based application. You cannot make this application online. So if you go to the Home Office, EU settlement scheme application form, it used to be online, but now they introduced form. There is a form. There are a couple of forms. One form will be just for Zambrano, right? There is Ibrahim Chan case law, so there are a lot of form, but Zambrano form, if you go to the last, if you download this form, in the last page, there are a list of document, what you can prefer. You can obtain and give this document. Now, once you submit, you can just fill up the form. You don't necessarily include all the evidence with the application form. You can fill up the form, send it by email, or you can post it. And after 10 days, you can send all the support document. But in any case, if you are a carer, you have already received letter from hospital, letter from GP, letter from school, letter from social care, letter from any other authority, right? So you have these documents. So you can send all these documents. If you don't have, contact with the GP, contact with the hospital, contact with the school, their head teacher, tutor. If social care involved, ask the social care. Ask them, give a letter. You have still plenty of time to obtain all these documents and make an application. If you can make proper application with the supporting document, you will get settled or pre-settled status, definitely. So, my brother and sister and my friends, if you are in a position, if you are a carer of a British child, if you're a carer of a British citizen, if you care of a British adult, a mother or father, if it's not necessary you have to be parents, anyone can, any citizen from anywhere. If you are from Bangladesh, if you're from Ghana, Nigeria, Afghanistan, Syria, okay, wherever you are from, what nationality you are, if you provide care to a British citizen, your grandmother, your uncle, your auntie, your relative, or no relatives, anyone, you can claim Zambrano right of residence. So this is the time, take the advantage. Of course, if you lack cover, you will get it, because if the Home Office win the case in appeal, you will not get it. I'll come back after short break to speak about the recent Nationality Act, the provision introduced by the Home Office, where a child will become automatic British citizen, on which circumstance, what condition they need to satisfy, and I'll speak about how long EU citizen can stay outside the UK without damaging their pre-settled or settled status, and some important case about coronavirus concession in terms of immigration law. I'll come after a short break. Stay with me. Yes, welcome back. Short break, not long. Now, let me talk about what happened those citizens who missed this deadline to settle status. The deadline was 30 June 2021. And many people missed the deadline. Hundreds, thousands of people missed the deadline. Are they overstay? Do they have any right to work or right to live in the UK? Technically, they are overstay. However, for the Home Office position, what they will do now? Will they be able to make any application? Will they be able to claim benefits? Now, the answer is published by the Home Office. What the Home Office is going to do, they will issue a 28 days notice to every person, whoever in their record, make an application within 28 days. This is the first one. The employer has to check whether someone has settled or pre-settled status. If you find anyone doesn't have settled or pre-settled status, he will refer him, or he will give him 28 days again to make an application. The person who didn't make the application missed the deadline. Immigration enforcement team detained him or found him. They will give him again 28 days time to make the application. Local authority refusing benefit, they will refer him to the Home Office. Home Office will give him 28 days. So in all scenario, EU citizen who missed the deadline, they will get a time 28 days. Like from Universal Credit, if they refuse, they will maybe give you 28 days. Home Office will give you 28 days. So Within this time, you can make an application. So this is for those who miss the deadline. Another exception is, which is general exception for those citizen, those EU citizen and their family member, is basically if you can show that there is a reasonable grounds or exceptional circumstance which prevent you to make the application. For example, you was victim of domestic violence, you was controlling by someone, and you had no opportunity to make the application, or you don't know English, you don't have access to internet. This is also an reasonable ground, and you can make the application. So there is still time. Those who miss the deadline to make the application, you can make the application with this reasonable ground. Of course, you need to provide evidence. Now, how long you can stay outside the UK? I already said that you can stay outside the UK for less than 5 years if you have settled status, or I'll tell you for pre-settled status you can stay out less than 6 months for pre-settled. But if you stay more than 6 months but less than 2 years, then you can continue to live under pre-settled status. It will not last, but you will not get settled status because it will break your continuous residence, and your pre-settled status will again stop. Anyway, but if you stay more than 2 years, your pre-settled status will lapse. Okay, you have to understand that if you stay more than 6 months, your continuous residence will break, and then you'll not get settled status. But if you stay more than 2 years, then your pre-settled status will lapse, and clock will start again if you in 6 month case. Now, EU citizen being denied entry to the airport recently. This is widely reported, and the reason is that it's not anything Home Office doing wrong, but you have to understand that now if any EU citizen want to come to the UK, their status is visitor. So you have to comply with term and condition of Appendix V, visitor, right? For example, if you want to come to the UK, you come as a visitor. If you tell the immigration officer when you come to the airport, they will ask you why you are coming in the UK. You say, I am coming to look for work. They will refuse your entry. You come to the airport because you don't need visa, but in the airport, they will ask you whether you come as a visitor or not. And if you are not satisfied this requirement, they will refuse your entry. And this is the reason many EU citizens return back to their home country. And now, this is very important case came in terms of 7 years rule. 7 years rules as a child. If someone under 18 or born in the UK, and if they spend 7 years under the provision of human rights, and they can claim leave to remain on the basis of their human rights Article 8. Now, there is a lot of case law, but the latest case law came last week, and Bangladesh versus Secretary of State Home Department 2021, and the court found that it is reasonable for a child to go back their home country with their parents, where the parents doesn't have any leave to remain in the UK. So unfortunately, it's not a good news. Now, this case outcome will be used by the Home Office and refuse, and next a lot of cases on the basis of 7-year rule. So if your child is in the UK who spent already 7 years, if you want to make an application, very important, you need to speak with a lawyer and made an application. Not only for just 7 years rule, you should include other human rights article as well with this, and that it will increase the weight of your claim. But if you just rely on 7 years rules, and if the parents doesn't have any leave to remain, then Home Office caseworker will refuse your application, because the question before the home caseworker will be, does it reasonable for the child to return his home country? And the same question was before the Court of Appeal, and the decision said that yes, it is reasonable to reasonable for the child to go back with their parents, with their home country. So this is very important. So when you make the application, I'll advise you speak to nearest immigration professionals, experienced professionals who will guide you and not only rely on 7-year rules. In addition to 7-year rules, you can include some other provision, some other human rights, because human rights is very wide. Article is very wide. It's private and family life. It's private and family are two different things. So private family life is uh, first private life when you are connected with the community, right? You establish your private life, your relationship among the community, among the people, cultural integration, right? These are the private life. Family life is your relationship with the brother, sister, wife, children, mom. These are the human rights community. So when you put all these materials together, human rights. In addition to that, you can put other significant obstacle what you will face to your homeland if you try to go back. Then the weight of your claim will be higher and there is more chances. If you just rely on a child 7 years, that my child will spend 7 years there, he have a right to leave to remain, then Home Office will answer that this is reasonable for you to go back to your home country with your parents, and they will refuse your application. Especially from the last week, this case, MA Bangladesh versus Secretary of State, where the judge said, or the decision said, yes, it is reasonable the child to go back to his home country. Unfortunately, it's not a good news for 7 years rule who are expecting. And then next, British child. The Home Office introduced a new section in British Nationality Act, and it is very generous section. I would say that this is the first time I see that where a child will be automatically British citizen despite their parents hasn't got settled status at the time of birth or British citizen at the time of birth. Home Office introduced on 1st July 2021 in the immigration rules that when a child born in the UK before 30 June 2021, if their parents was eligible for settled status at that time, but they didn't make the application, or they made the application but they didn't got the decision, then their child will be a British citizen. So many people maybe will be able to get a British citizen automatically, many child. But general rule is if the child born in the UK and the parents get settled status subsequently, then they have to register the child as a British citizen, paying £100,000 home office fee, fill up application form of 60 pages, some other formality, and the child is naturalized British citizen. But in that case, the child will automatically become a British citizen, and despite their parents have no settled status. And the last update I'll give you about coronavirus concession. Many people send me email as well, and they call my office and ask me that during the coronavirus their income was reduced. They used to earn £18,600, but they are not getting any enough income because they are in furlough. What they can do? Well, long before Home Office update their immigration rules, coronavirus concession scheme, that is, if you lose your income because of the coronavirus, or if you are in furlough, or if you self-employed, first principle is if you are in furlough and if you are earning 80%, Home Office said they will consider you are earning 100%. So your income is currently £16,000. The Home Office said they will consider £18,600. This is the first principle. The second principle is those who lose their those who have lost their job, those who have lost your job, you don't have job now because of the coronavirus, company shut down, you have no more employment. Home Office say if you satisfy the financial requirement before March 2019, then they will consider you now, although you are in benefit, you now satisfy the financial requirement. Self-employed people, again, if you receive any grant, Home Office said they will consider your income. If your income is reduced due to the coronavirus, they will consider that that has not reduced. There are also some exemption available. Also, fee waiver application, still you have an opportunity for make a fee waiver application if you need to. In terms of no recourse to public fund, you still can change the condition The Home Office are very generous still, so take that advantage. And good luck, everyone. Everyone, take care and look after yourself. Thank you very much.